Hello and welcome to Credit Makes Sense with Netiva, the Frugal CrediTnista. I'm a certified credit counselor, personal finance coach, and owner of M&H Credit Solutions, where credit transformations happen. We teach our clients to destroy their debts, grow their money, and soar their credit scores. So the other two videos that I have done thus far have discussed collections, what to do when the debt collector calls, what to do when you receive a letter from a debt collector, and how to understand your rights and to pinpoint violations. So I got a lot of questions on, okay, well, I've pinpointed some of the violations that you said. What should I do now? Should I call them out on it? Should I get to filing some type of complaint? You are going to stack your violations. Number one, you still want to find out the validity of the debt. Is it accurate? So I wanted to go over some of the things that I have wrote about in my new book. So that's why it took me so long to post a follow-up video, because I have been writing this. Stop Hiding 10 Proven Strategies for Facing Debt Collectors Head On. At first I was just going to make it an ebook, but a lot of people don't read Kindle ebooks. So they were like, put it on in a real book so I can get it for you. So I have done that. I literally just hit the publish button, so it should be available in about 3 business days on Amazon.com. So I'm super excited about that. But okay, back to the collection issue. So now you want to validate the debt. So a lot of people are like, what is validating the debt? What exactly does that mean? So I have a definition for you. As always, I'm always very technical like that. So according to Black Law's Dictionary, validation is assessing an action to determine if it is complete, correct, implemented, and delivering the correct outcome. So what does that mean? Basically, validation is proof. You need that documentation to determine if every aspect that they're reporting in, that they're trying to collect from you, particularly the amount, is truly correct. Is it accurate? Is it complete? Does it prove that their claims of being in ownership of this debt, is that true? Is that accurate? Can they implement these actions based on the information that they've given you? So that's what you're looking for with validation. The reason why I said is that so many times people send a validation letter, and then, you know, the company, the debt collection agency, sends back like a bill, and they're like, oh, well, they validated, so I paid it. Since when does a bill tell you that everything that they're trying to collect, and even if they even have a relationship with the company that they claim they're collecting on behalf of, it doesn't show you any of that. If you looked up some of the complaints with the FTC, Fair Trade Commission, you'll see that there are a lot of companies out there that are scamming people by sending them that one bill, which can be generated off of any Microsoft or any other type of software. So you want proof. So I'm going to go over just a quick list of some things that you can ask for in your validation letter. Keep in mind that the Fair Debt Collection Practices Act, which is what I mentioned quite a bit in the other 2 videos, it's not super specific as to what validation is, but I'm just going to go over some general things that you should be asking for in your letter, and then I'm going to follow it up with what you can ask for in addition to. So number 1, they should be identifying the original creditor. They shouldn't just be saying, well, we bought your Sprint bill and you owe us now. So it said you should be Sprint, and if you ask for their information, Sprint's information, they should be able to give you that information, because if they bought it, they should have that information, right? So identify the original creditor. You can ask for a copy of the original contract. Now, some of the letters that you may see, if you're looking up templates online, it'll ask for the original contract with a wet signature, meaning your signature with a pen. However, a lot of our transactions are done where? Online. So you always have a wet signature, but you still want a copy of that contract with an electronic signature, and that should be readily available from their files as well. So you definitely want that. You want a copy of the contract between them and the original creditor. Why is this important? A lot of times they will not give this to you because it shows how much they paid for the debt. And that's something I like to know. How much did you pay for the debt? But on top of that, I also want to verify that you actually have a relationship with the original creditor. Otherwise, I just have your word. Now, sometimes in place of that, they will have the original creditor. Since we use Sprint, they'll have Sprint send a letter saying, yes, we did sell this debt and this amount to, I don't know, portfolio recovery. But they won't tell you how much they sold it to them for. So you can definitely ask. I like to know, because it helps with negotiations, and that's why they don't want to tell you because it helps with your negotiations. You want proof if they are licensed or bonded. I will tell you, not all states require this. Not all states require this. So you will need to look up your state and see what they require. I do have a link available on my page, mnhcreditsolutions.com, under the resources section. mnhcreditsolutions.com. If you click on resources, you'll see I have the helpful link set, and then you can click on that and it'll tell you what specifically your state requires, because some states, such as, what am I thinking? I know Wisconsin, if you are out of town, as long as you don't physically come into town and try to sue one of their residents, one of Wisconsin residents, you don't need a license. So that's what I mean, licensed and bonded, because you don't need all of that as long as you are just mailing and calling. But the moment they decide to pursue legal action against you, then they will need to be licensed and bonded in your state. And that's a good thing to look for when you are being summoned or sued, to see if once they entered your state, if they complied with that and use someone who's licensed and bonded in your state. So you want a complete transaction history. So this goes back to that bill. A bill is not a complete transaction history. You want to know how they got to this amount, because a lot of times what happens is that you have this account, the account was closed or charged off. The account was closed and charged off. Sometimes there's a period where interest stops accruing, and then once it's sold to a collection agency, there's requirements either by your state or within a contract where interest can at that point continue to accrue. So you may notice that the original creditor may have a debt for like $1,000, and then by the time the collection agency comes after you, the amount is now like $1,149. You want to know how they got to that new amount, and you also want to check to make sure that the interest or the I should say a full accounting that they give you matches to the percentage that they're legally supposed to be charging you, whether by your contract or whether by your state. Your state's rules will overrule what's within that contract, because there's that cap that they can only charge you. So you want to check that as well. And you also want proof that it's within your statute of limitations. Now, typically you can look this up yourself just by going on your credit report, but I have had some debts. The statute of limitations is like 10 years, which is past the 7 years that negative information stays on our reports in most cases. So, it's still within your statute of limitations, but you still want to know, okay, well, you proved to me that it's still within the statute of limitations and you can collect on this debt. Now, some states state that you cannot even collect once the statute of limitations have passed, and others just specify that you can still pursue collection activities, but you just can't sue. Keep in mind, with statute of limitations, actually let me define it. Statute of limitations is a time frame that your state sets that a creditor can come after you to enforce the debt. Basically, in layman's term, it's a time frame that your state sets that a creditor can sue you to make you pay for the debt by obtaining a judgment to garnish your wages, levy your bank accounts, or put a lien on one of your assets. So that's why the statute of limitations is so important. If the debt is past the statute of limitations, meaning they can no longer sue you, the only thing they can do is call you and mail you, and you can put a stop to that because they can't sue you and force you to pay for it. And usually the debt is like so old that it's not even affecting your credit scores anymore anyway. But you want to make sure that they know if it's past the statute of limitations and can prove that. And you just want it for your own records as well, because sometimes it's not always black and white and you can't find that information on your credit reports. You want to inquire if they have moved forward with pursuing any legal actions. Have they filed any lawsuits? Have a judgment been filed? I have had where clients did not know in a small claims court that a judgment had been filed against them, and the creditor or the collection agency came forth and said, yes, we did file a judgment. Here it is. Many reasons for that. Basically, it comes down to being served properly, another time ignoring summons. So it could be a number of reasons for that. So you want to ask for that as well. And you also want to ask for any insurance claims. A lot of people don't do this, and a lot of companies don't like to provide this. So what typically happens, and this used to be in a lot of credit card contracts online, like in the terms and conditions, I've noticed they're starting to take those out. So most companies have, particularly credit card companies, have insurance on the debt. So not only do they write the debt off and charge it off, so there's a minor tax incentive for that. I guess you can call it incentive. And then there's the insurance. So they file insurance on the loss and they get paid for that. And then they sell it to the collection agency and then they get paid for that. So knowing if the insurance has been taken care of, it kind of allows you to know who should. It's like, well, the debt has been paid by insurance. They got the tax incentive. They sold it to you. So that's one of the reasons why I don't like to give it to you. That's one of the reasons but I still ask for it. And then you want to limit communication to writing only. Limit communication to writing only. Reason being, a lot of times, A, phone calls are stressful, especially unexpected phone calls. B, we don't want to incriminate ourselves. There are some states where oral acknowledgement of the debt is considered valid. And if they're taping the phone calls like they say they are, you don't want to put yourself in a predicament where you've just acknowledged a debt over the phone inadvertently. And now they're like, okay, well, we restarted your statute of limitations. Fortunately, most states you have to write, acknowledge, like literally write your acknowledgement of the debt. But there are some where you do not. So just to be on the safe side, get off the phone. Tell them to just communicate with you in writing. Now, if you're decide to settle the debt and work out some type of payment arrangement, then from there you can make a phone call. But it'll be on your terms when you're prepared and you are ready to make some type of payment arrangement or settlement amount on your terms. So it's like you already got everything together. That unexpected phone call can really throw you off. So here's some other things that I've seen in some letters that you can most certainly ask for. The amount of the debt, the account number, explain how everything was calculated, the date the debt became payable, the first date of delinquency, the amount that the collector paid for the debt. So these are some of the things, but there's not too many, like I said, specific things that the Fair Debt Collection Practices Act states that you can ask for. So what do you do in that case? You go to your state collection laws. There are some states that exactly mirror exactly what the federal state laws say, but there are others who do a great job at adding and defining what specifically a collector must do to be able to collect debt collect funds on a debt. And that is Texas. Boston has great ones. Arkansas and Alabama are pretty decent too. Even Illinois has some nice little tweaks here and there that allows you to ask for more. So just check out your state collection laws. It's just a matter of Googling them. I will admit, a lot of time when you read some of these states, anything, I mean, those statutes are really like, woo, did you really want me to read this as a consumer, a regular consumer? They can be something else. So what helps me are attorney blogs. I love attorney blogs. For one, if you are a blogger, you know that it takes an incredible amount of time to collect that information and put it into a format where consumers will be prompted to reach out to you. So if an attorney or even a paralegal that they may be paying took the time to put that much information together, to break it down in layman's terms, and then say that they give free consultations on top of that, like that's how I find out a lot of legal cases and all that good stuff, legal assistance for cheap or very little consultation fee for my clients, just from attorney blogs. Like, I really love them, and I just create a nice little portfolio of different attorneys in the states that I do a lot of business in. And it has helped tremendously. Another place, if you just want to understand what a collector or creditor can and can't do when attempting to collect on a debt from you, is your Consumer Protection Office. Your Consumer Protection Office is awesome sauce because their job is to protect you, the consumer, and they will educate you on a lot of things. It's totally free, and it's in most counties, municipalities, cities. You literally just type in where you are, your county, and Consumer Protection Office. Another place is the state's Attorney General's office. They will actually intervene on your behalf. That's some other than take complaints, of course. So you can, if you have an issue with a creditor, utility company, I actually use them a lot for utility companies, but they also are really good at educating you about your rights and intervening in your behalf. So if you have like a complete butthole of a collector on the phone, or that's calling and harassing after you told them to leave you alone, or act like they don't understand when you said, only write me, it's, you know, some can just be really rude. That's who you would call. Like, okay, yeah, I talked to so-and-so at this state from this company. Come on, state attorney general's rep, this is what I need you to do for me, or what can I do, or what can you do for me to stop this and nip this in a bud. Also, there's I have it in my book, I don't have the name of it now, but there's an association that most debt collectors are a part of. I file complaints from there when they're being buttholes. So just pull on some of those resources and get my book. Stop Hiding 10 Proven Strategies for Facing Debt Collectors Head On. I have the link below. But the next step, as I mentioned, you got the phone call, you got the dunning letter that we spoke about, the letter that you received. This is an attempt to collect the debt. And now you write the validation letter. After the validation letter, they're going to give you responses. You're going to wait for the response. It's going to take about 35 days, maybe 35 to 40 with mailing time. Your time to mail it to them. When they receive it and then send back to you, that's why you want to send it first priority or certified mail so you can track it. You want to get the signature confirmation so you'll know when they receive it. As soon as you get that receipt with their company representative signature on it, you are going to start tracking from that time frame that they received and signed it, 30 days from there, and then a few days after to get it sent back to you. If they do not respond, which is sometimes what happens, they cannot continue collection activity. So this essentially means that if you dispute it off your credit report, they will have to take it off because they can't respond. They haven't validated the debt to you, which means it is now an unverifiable debt, which means they should not be communicating with the credit bureaus at all, because anytime a company, especially a collection agency, reports anything to credit bureaus, that is a form of collection activity. So if all collection activities must cease and desist, so there's your reporting on your credit report. It must cease and desist. When you get the responses, like I said, the number one thing you're going to get back is a bill. I always get, well, I got a bill. Is that validation? Look at what you asked for. Is a bill what you asked for, or did you ask for specific things that you need in order to prove that this particular debt is correct? Let me read the 4 things that validation does. Complete, correct, implemented, and delivered the correct outcome. Okay? You need to see if they are really who they say they are, representing who they say they are representing, the amount is correct, and that the dates that they're giving you, all that information, you want to see if it's factual. Is it correct? Is it complete? And that's what validation is. You need that proof. And a bill is not proof. Okay? So hopefully this information was helpful. If you have any questions, drop them in the comment box. Please feel free to sign up for my email list. I'll leave a link for that as well. I share videos and a lot of commentary as well, just to educate you guys on your consumer rights, on credit, on money management, and all of that good stuff. My coaching program is based specifically on educating, equipping, and empowering you to create your own credit transformation. And of course, if you need personal one-on-one assistance, you can always feel free to come out to me. And reach out to me rather. So the book goes through all of this. I go through the definitions. I give you snapshots of example. I give you little pieces of case laws that I mentioned in the other 2 videos. I give you sample dispute letters for you to send out and what you should be asking for. So I really took all of the questions that I get, gathered them up, and made a book to answer step by step the questions and the format, and how you should follow up, what responses you may get, etc. So pretty proud of it, but I can always make changes, so your feedback is definitely welcome. So I left my contact info in the comments section, and I look forward to hearing you guys' feedback. Enjoy your day.